The Parliamentary Service Commission is established under Article 127, Sub-Article 6 of the Constitution of Kenya. The Commission is responsible for 1. Providing services and facilities to ensure the efficient and effective functioning of Parliament. 2. Constituting offices in the parliamentary service and appointing and supervising office holders. 3. Preparing annual estimates of expenditure of the parliamentary service and submitting them to the National Assembly for approval and exercising budgetary control over the service. 4. Undertaking singly or jointly with other relevant organizations programs to promote the ideals of parliamentary democracy. And 5. Performing other functions as prescribed by national legislations. In furtherance to its mandate, the Commission established the Center for Parliamentary Studies and Training (CPST) as its capacity-building arm. The establishment of the CPST is anchored in Section 34 of the Parliamentary Service Act of 2019, which states that the Centre shall provide learning and development programs to build capacity for members and staff of Parliament and other stakeholders.
In 2008, the CPST, the Center for Parliamentary Studies, Training and Studies, was mooted and regulated within the context of the Parliamentary Service Commission Act. The purpose of setting up the CPST was predicated on the understanding that Parliament spends quite a large sum of money on training of its staff, its members of Parliament, and all other people who work with it. In the process, the CPST has grown. It is now on its highway to become a full-fledged institution with a linkage to one of our top universities, the University of Nairobi, where we have an existing memorandum of understanding.
It has made tremendous progress in the implementation of its legal mandate of capacity building. It particularly responded swiftly to the changing governance structures in 2013 to ensure it expanded its services to include the requirements of a bicameral parliament and the 47 county assemblies.
After every election cycle, the leaders that join the county assemblies or the National Assembly are drawn from different backgrounds. No one comes here with the knowledge on how to be an effective representative, whether a member of parliament or a member of the county assembly. And therefore, it's very critical that before even they embark on their roles as people mandated to oversight governments, they're equipped fully to undertake that mandate. And so far, the Centre has been incredible in terms of discharging that mandate.
The Centre draws its strategic and policy direction from the Parliamentary Service Commission through the CPST Board. The board consists of 12 members drawn from the larger Parliamentary Service Commission. It is responsible for the implementation of the 4 strategic pillars, namely effectiveness in capacity building, excellence in service delivery, institutional development, partnerships and collaborations. Successful implementation of these 4 strategic pillars will enable the Parliamentary Service Commission to achieve its vision of a democratic and people-centered parliament. The board is guided by the Centre's vision of being a global center of excellence in legislative governance.
We are looking at CPST to be a global center dealing with parliamentary issues and training. I'll look at it as a funnel that draws from all over the entire world, coming down to a region called Kenya. We've had delegations from Africa as a region who come here to learn, and they do the training here. When it comes to the budget of CPST, I'm representing CPST in that finance committee. And also training in any organization. Training is expensive, so you have to invest in training for you to get the best output. when it comes to delivery of services.
The Center for Parliamentary Studies is working to ensure that its capacity building programs lead to new knowledge, change of attitudes, and change of mindsets. It therefore designs training and capacity building initiatives that offer practical interventions aimed at the realization of the global development agenda.
We look at the areas that will really be important for that clientele by paying special attention to members and staffs of parliaments, both in Kenya and regionally or abroad, is to look at the constitution and systems of governance. That's one broad thematic area. We also look at legislative and procedural matters, a big space in this space of parliament, because it doesn't matter who you are, you get elected, you don't understand procedure. So we also look at information and public engagement as a key theme in our curriculum. Why? Because of the big emphasis on public participation and the issue of public trust in the constitution. Then we look at public finance management, since Constitution 2010 plays a lot of budget-making role within Parliament. So for that reason, unlike before the 2010 Constitution, we must really help members to understand the whole cycle of PFM. And for us to do that, then we have a theme on PFM. Then we have the issue of human resource administration of Parliament. The Parliamentary Service Commission itself is a body corporate that is an employer. So there's a lot of human resource matters, both at national and county level, so that's another key theme. And then we look at other cross-cutting issues, ICT, gender, security, protocol, media. They're cross-cutting because it doesn't matter which of the other themes you're working on, these matters will always come in. We are introducing our fellowship program. It's awaiting to be considered by the board. That fellowship will bring in academics, postdoctorals, postgraduates, people who have done a master's, they come here, spend 2 years, enhance their research in parliamentary and democracy, and these will be deposited within the CPST. This will be the place where former members of parliament will be gathering at what we are calling the former members of parliament in a kind of social club. Why? Because they need a place they can share their knowledge. I want to be remembered as the person who made the CPST, not alone, but with an amazing team.
The core clients of the CPST are members and staff of Parliament, members and staff of the county assemblies, and members and staff of other regional parliaments who look up to the Centre for their capacity building solutions.
The legislature is the one place where you can never be complacent. The legislature is the one place where you never get to the place where you believe that you have now mastered what it takes. The legislature, because of its design as a legislature, the legislature is so designed to resonate, reverberate constantly, every day, the pulse of the nation, the changing needs of society. Because of that, you can never be in the place where you are fully trained and fully capacitated to serve the legislature.
For exposition and continuous enhancement of knowledge, skills, and experiences.
CPST has had profound impact on members of Parliament in the National Assembly and our staff. The training that CPST has offered over the years and the collaboration with other institutions has enabled the members of National Assembly to be more responsive, to undertake their duties of oversight and representation better. It has made our work easier as clerk and staff of the National Assembly with respect to capacity building. We have seen CPST retool their skills. We have seen CPST collaborate with other institutions to offer specialized courses to our members of Parliament and staff.
The Centre has developed state-of-the-art capacity building programs that respond to specific needs of its clientele. Among its collaborative clients is the County Assemblies Forum, which serves as the coordinating body for the 47 county assemblies in Kenya.
The county assemblies today rides on enhanced capacity of members of county assembly to discharge their responsibilities and representation, oversight and legislation, and all this we owe it to the role that CPST has done over the past years.
It also has the Society of Clerks at the Table, that is devoted to the exchange of best practices and optimization of legislative procedures among Kenya's county assemblies.
Since devolution began in 2013, I've been able to see the birthing of devolution in the county assemblies. I've been participating in many activities, and a major stakeholder in enabling us to entrench devolution in the legislatures in the county assemblies is Center for Parliamentary Studies, which has been the major institution that has been training the staff of the county assemblies on legislative procedures, legislative drafting, on budget making process, and all that pertains to legislation, because the work we do in the county assemblies is the similar work that is done also in the national parliaments in our country, Kenya.
Through the innovative capacity building programs, CPST will effectively facilitate members of parliament to discharge their constitutional mandate of representation, legislation, and oversight efficiently.
If you look at all professions, there is always continuous professional improvement on what you are doing, whether you are a doctor, whether you are a lawyer. There is always that opportunity to enhance your knowledge in that field. So the center has been a very good avenue of enhancing the legislative and oversight skills for our members and by extension the staff of Parliament, because Parliament brings in people from all professionals. You'll find teachers here, you'll find doctors, you'll find lawyers, you'll find businessmen. So it's good to give them a place where they know that they will get a good introduction on their new career. Because once you join politics, you are basically taking up a new career. You need to understand the process of initiating bills, the process of looking at laws that are in place, how you can amend them, the process of being effective in playing a role of oversighting so that Parliament can be an effective tool in providing checks and balances on the executive.
CPST has provided quality capacity building services to parliamentarians, and as a result has created a well-functioning parliament. This training has adequately prepared me in the way of instilling the necessary skills. We are proud of CPST because it has also given us negotiation and lobbying skills. You know, now we are well trained. We are at a better position to handle and effectively negotiate and lobby for resources, opportunities, having undergone CPST programs.
The Training of Trainers program targets persons interested in improving their training and facilitation skills, especially for adult learners in the legislature, as well as the public and private sectors. The program also acts as pre-qualification tool for the individual resource persons engaged by the CPST, both as internal and external trainers.
I have attended a lot of training, as you could understand by virtue of my job. But the training
Good afternoon, everyone.
Good afternoon,
thank you so much for joining us this afternoon as we have our webinar. My name is Wayua Mutisia, a senior ICT officer in Parliament and chairperson of the webinar committee by CPST. And I want to welcome you to our first webinar of this financial year, and also the first webinar that we are doing in collaboration with the African Colloquium of Legal Counsel to Parliament. So this is the webinar that we're going to run for an hour and a half. And without much ado, I want to invite Professor Nyokabi, the ED of CPST, to take us through and to officially open the webinar. Thank you.
Yeah, thank you very much, Ms. Wayua. Good afternoon, good morning, depending on where you are joining us from. As you've heard, my name is Professor Nyokabi Kamau. I'm the Executive Director of the CPST. Mudhomi, when you take over to moderate, I'll hand over to you, then you can introduce me properly. But in the meantime, I want to just welcome all of you who have managed to join us. This afternoon, I want to welcome in a very special way our keynote speaker joining us from South Africa, our all legal officers, senior officers, directors, deputy directors from various parliaments in the continent. I want to really thank you for choosing to do this webinar with the legal colloquium with the CPST. The CPST, as you've heard, if you joined early when the documentary was playing, is the training arm of the Parliament of Kenya. It was established around 2008, but for now it's grown to be a proper regional center of excellence, training members and staff of the National Parliament of the 47 county assemblies of Kenya. And indeed, in the continent, we have put our mark as the leading parliamentary training center. Globally, we are well known. We also work with partners. We are in MOU with McGill University. We have a memorandum of understanding with the UNITA, and through them, we've run very premier programs. Here in Kenya, we have a memorandum with the University of Nairobi, and we run very premium programs, including these webinars that we now hold either alone or in collaboration with other institutions. This particular one was requested by our own Dr. Okero, who I believe is head of the legal colloquium in this country. I think he's the SG. And unfortunately, he was not able to join us because as duty called, he had to travel. Even me, I was almost missing because my eyes were being tested for something and I can hardly see properly. They're very blurred because of the tablet they put, but thank God I am here. And I'm really excited about this conversation about public participation. Without much further ado, my co-moderator is Japheth Mudhomi. He's aware that he'll do most of the work as I'll be doing most of the listening. And therefore, I now open the floor and welcome Mr. Japheth Mudhomi. And I want to just introduce him to us. Mr. Mudhomi is currently a Deputy Director in the Parliament of Kenya, specifically working in the Office of the Speaker of the National Assembly, where he leads on public participation, public communication, and media. And I believe public participation sometimes touches on public communication. And Mr. Mudhomi is a trained public relations officer. He has many years of working from universities, and then he joined Parliament about, I think, 17 years ago. Mr. Mudhomi is also a lawyer, an advocate of the High Court of Kenya, and he also is a renowned trainer for CPST, one of our best TUTs, initially trained by UNITA and later on trained by CPST, but also he has practiced a lot as a TUT. Mr. Mudhomi is a father of two.
To this webinar. And my simple duty today is to introduce the keynote speaker and the moderators, and also to tell you to keep checking the chats in case there are any questions from participants. Participants, please, in case you have any question, you may place them on the chat. In the event that you might not get a chance to verbally prosecute your question towards the end. And at this point, I want to confirm that we have Mr. John Dakana, our main speaker in the House. Yes, we do. And I want to introduce him right now. Mr. John Dakana is the Director of Public Participation. He started his career with the Free State Legislature. I think that's a provincial legislature in the Republic of South Africa, as a public participation officer immediately at the inception of a democratic South Africa. He became a director in the year 2014 after the Constitutional Court had hammered the lawmaking institutions in South Africa for failure to ensure adequate public participation and oversight as well as the lawmaking process. People from the Kenyan jurisdiction, this you must be familiar with, on the number of acts that have been declared unconstitutional for want of public participation, including having quite some precedents from the Kiambu County Assembly case on the financial bill. Then he has contributed immensely in the drafting of legislative sector, oversight model in South Africa, particularly in relation to the public participation. He is highly respected within the sector in South Africa. I want to take this opportunity to welcome Mr. Jongi and to make the main presentation as the keynote speaker. You have 20 minutes for the presentation, after which I'll allow you maybe with the 5 minutes to go in the event that we'll have delayed. Welcome, sir, to make the presentation.
Good morning.
Good morning.
Good morning, and thank you very much, colleagues. I must say I am truly humbled and privileged to join the ranks of my colleagues to speak on this important subject. You will note that our country evolved significantly, influenced by the country's transition from apartheid to a democratic society in 1990. The end of apartheid in 1994 marked a pivotal moment as the new democratic government emphasized inclusive governance and citizen engagement in policymaking processes. In 1996, the Constitution of the Republic of South Africa institutionalized public participation by mandating that a government must be accountable to the people, thereby establishing frameworks for public involvement in decision-making. I think briefly, the background historically would know that South Africans, blacks, coloureds, and Indians in particular, were largely excluded from the government. It was only when, under the pressure of international sanctions, that the Nationalist Party government came with cosmetic changes where it co-opted some of the professionals and some leading figures among communities to participate in structures of governance that unfortunately did not see the end of day because it did not extend to the right to vote by people of the country, by all. It was only the white population that determined the policy direction of the country. And unfortunately, it was only beneficial to the white citizens of the Republic. So it was largely suppressed during apartheid. There was no public participation. Government would make and change laws willy-nilly. And I think the struggle against apartheid strengthened amongst the liberation movement the determination by communities to wage a war, both militarily and also by mobilizing its people to resist the apartheid laws. You will note that one of the strengths that public participation in our country strength is drawn from the important historic milestone that took place in 1955 at Congress of the People, where the Freedom Charter was adopted. It was attended by thousands of people on horseback, by train, by car, by foot, where they developed a document of what would become a significant document that contributed to the Constitution of the Republic of South Africa. While the concept of a democratic state in our situation, because of our historic background, refers to diverse forms of citizen participation and representation. Our approach is that those obligations do not end only during an election. It goes further in ensuring that there are organs of people's power that are providing support to the government and the governance of the country. You will note that the South African Republic and its constitution had specific legislative frameworks that applied to parliament and provincial legislatures, as well as local government, in ensuring or legislating the process of ensuring public involvement in the decision making. Therefore, in our view as a country, we believe that public participation is central to the core function and constitutional mandate of the legislature. And it promises that all citizens, irrespective of race, creed, age, will influence decisions by recognizing and communicating these needs in the interest of all participants. Public participation, therefore, it's not an event, it is a process. We have to ensure that when you prepare, for an example, for each policy formulation process, we solicit involvement of civil society organizations, individuals, communities, interest groups, advocacy groups, to participate in these open forums, because one of the principal decisions of the South African government is to conduct all its business in an open and transparent manner, with all the views of the population given space. We also ensure that the process of lawmaking is not only one way, that of public representatives indicating what they would want to change, but because it affects the people that the legislation or policy is intended for, you have to create that platform and space for our people to engage. Therefore, these processes is one of the efforts of deepening not only democracy, but public participation in our lawmaking processes. And then we will ensure that as we embark on these processes, public values, interests, and needs and desires are accommodated in the end product of what the government and the legislature is intending to do. So all of these have got serious implications in the constitutional framework of our country. One of the things that we have done is that one or some of the advocacy groups once took Parliament, the Speaker of the National Assembly, to the Constitutional Court when the court ordered that the legislative sector have failed to comply with its constitutional obligation to facilitate public involvement when considering the legislation on Traditional and Khoisan Act of 3 of 2019. The Constitutional Court said that most of the public hearings where the legislature and parliament has invited public input when it considered this legislation, most of the areas where this public hearing was conducted was largely not those of traditional authority where people could effectively make inputs that would make this traditional and Khoisan Traditional Leadership Act to be appropriate to those communities that it was facing. It is where then we had to develop a code of ethics that is guiding us as public participation practitioners, that as we meet communities, we should clearly define what the purpose of this process is and what these roles us as practitioners can do to enable to make better citizens with better decisions with citizens and ensure that we incorporate all their interests and concerns on the outcome of what the legislation under review is going to do. Next, please. We also, based on the outcome of this constitutional judgment, had to ensure that we must fully disclose the intended and the consequences of the legislative framework that we are considering, so that people must be, one, understand and be able to evaluate whether that decision that is being made is going to make their lives better. And that, number two, that all those who participate in that process have been given a fair and equal chance to make their inputs to ensure that the outcome of the public hearing meets its obligational challenges. The other important thing is the access to process, in ensuring that people do not only come to terms with the pieces of policy under review. They must get them in time, and we must take them through a workshop process where they understand what this process is going and how is it going to affect them. But what also is important is that we have to respect the communities and avoid polarizing by coming with predetermined outcomes of what we want the policy to achieve. Because we would know that at times a policy formulation process has a predetermined outcome. People or sometimes lawmakers want to achieve 1 and 2, and communities have got 3 and 4 that they would want to add in this discourse. But unfortunately, you find that communities don't respect or loses trust to these processes, because at the end of the day, they find that or discover that the issues that they have raised are not all captured in the policy making process. But one of the important things that we always encourage our public representatives to do is to remain committed to the commitments they make to the public during these processes. It shouldn't be that we are just doing a checklist of issues that we have met the threshold and so on and so forth. But what is fundamental is the contribution and inputs of what people make to ensure that the outcome of a policy does take the interest of the entire citizens who have participated in this policy development framework. One of our biggest problems in our country is the diversity. We have different opinions, different perspectives, on almost each and everything, whether it be race, whether it's culture, and so on and so forth. So we always ensure that this diversity is affirmed each time our programs are implemented. And we ensure that as we run these programs, mutual respect, integrity, and encourage people to buy in that their contribution to the outcome of the policy will add value. And these ethics to us, they define the expectation and aspirations of the public participation process. The public participation goal, in our view, has got 5 components that if you do not include this, the outcome of this process might not be seen or perceived to be a legitimate process by those who participate. Firstly, is to ensure that we inform our communities. We provide the public with a balanced and objective information to assist them in understanding the problem of the policy that we are looking at. Number 2, we ensure that we consult them and ensure that the feedback that they give us is analyzed, and we look at the alternatives that they are proposing, so that when we come to the decisions, it is a decision that they also find resonance with. But what is more important is involving and collaborating with them, is to work directly with them throughout the process, ensure that their concerns are and aspirations are understood and considered during this process, but we make sure that they are our partners during this process, because at the end of the day, the policy that is under review will be the policy that will affect their daily lives as they carry out some of their activities.
Mr. Jongi, you have 5 minutes. 5 minutes, please.
5 minutes.
Yes.
Oh, let me rush. Let me rush. I think one of the things in our processes of interaction with the people, which has been one of the difficult problems, are factors that inhibit participation. The external factors will be the political controversies that perhaps are perceived to be faced by the government of the day, or the history of neglect or mistrust of the democracy, of the political system, the equity concerns, the apathy, the cultural, racial, and gender identity, which is one of the biggest challenges also that we are confronted with. But the internal factors is our inability as the state to reflect the public input in the development of the budgets, policy development, and giving feedback to broader communities to ensure that all the issues that are raised are aligned with other governance processes, and failure to use the opportunity provided to engage with our people to make their contributions fundamental in our policy making. And I hope, I know that I may have said a lot, but I trust that this presentation will be shared amongst my colleagues, so that we are able to arrest some of the challenges that we are faced with. And as I'm saying, we are trying to find and develop a common strategic stakeholder framework for all provincial legislatures and parliament in the country, so that we are able to ensure that the members of parliament and the legislature are able to conduct their oversight, but also ensure that they encourage public participation in the areas where their constituencies are. Thank you very much for the opportunity.
Thank you so much, Mr. Njongi. If we can from the chat, you can able to get the clap emoji. Please give him plenty of them for that good main presentation. It's now my duty to invite the discussants to come to the topic. And I want to request that when you are making your presentation, please, discussant, your part, be a bit slow so that the interpreter may be able to interpret with the right pace to the people hearing you. But before I invite the next discussant, I want to acknowledge the presence of a number of office holders who have joined us. I know we have a number of clerks and deputy clerks, and as we compile their names, I want to acknowledge the presence of Madam Christine Mududa, Deputy Clerk, Mombasa County Assembly, that's the coastal county of Kenya. I also want to invite Madam Eunice Gishangi, Director Clerk of the Senate, the deputy to our patron, actually like our deputy patron. Welcome, Madam. The rest will be able to acknowledge you as we move on. At this point, we have heard from Southern Africa and the southern region of the Colloquium. We want to come to Eastern region of the Colloquium. And I want to invite Mr. Solomon Wilson Kiruda, our first discussant from Parliament of Uganda, the National Assembly of Uganda. Solomon Wilson Kiruda is a lawyer who has distinguished himself in the act of drafting legislation and advising legislature at the Parliament of Uganda. He is currently the Director, Legal and Compliance Services at the Parliament of Uganda, where he has served and grown through the ranks since 2007. While at Parliament, he has played a significant role in drafting private members' bills, amending legislation, drafting motions, petitions, and questions for oral answer, and also representing Parliament and Parliamentary Commission in courts of law. His experience is drawn from his previous practice on the bench as a magistrate with the law firms, companies, non-government organizations, and individuals he dealt with before joining the Parliament of Uganda. Mr. Kiruda is an active member of the Uganda Law Society, the East African Law Society, the African Colloquium of Legal Counsel to Parliament, and the Commonwealth Association of Legislative Counsel, CALC, where Dr. Okero, whom I am representing here, is the president. He received a Master's of Law degree from University of Western Cape, South Africa in March 2006, majoring in international trade and human rights law, and received the Bachelor's of Laws degree with honors from Makerere University in 2003. He's a certified compliance professional, certified pension specialist, and many others. Solomon has previously engaged as a legislative expert for European parliamentarians with Africa, AWEPA. He is admitted to practice law as an advocate and commissioner for oath and notary public in the Republic of Uganda. Solomon Kiruda, the moment is yours. Thank you. Welcome. 10 minutes. You have 10 minutes to give your take as a discussant.
Thank you very much, Japheth, for that kind introduction. And I would like to thank Mr. Nakana for clearly articulating public participation. I noticed that he has answered the questions as to what is public participation, why is it important, and has stipulated a code of ethics that should be followed while doing this. Now, on my end, I would like us to agree on one thing as I start. Now, the duty to consult is a fundamental principle of administrative justice and democratic governance. It mandates public bodies, including the legislature, to engage stakeholders before making significant decisions. Why do I highlight this? Because it ensures transparency, inclusivity, and well-informed decision-making. Now, a lot has been said, but for purposes of comparative purposes, and to fit within the 10 minutes before Japheth chases me away, I would like to quote one author called Mwale, who concludes
that the reason for engaging the public is that people are the custodians of democracy and should be involved at all stages of legislation. The process must empower people rather than inhibit them by creating opportunities and avenues for individual effective participation. I thought that was important. And it is also important to know that it is not only in Africa, but stems right through the instruments that we have chosen to follow. Article 21 of the Universal Declaration of Human Rights, which talks about democratic participation, Article 25 of the International Covenant on Civil and Political Rights, and at regional level, Article 13 of the African Charter on Human and People's Rights, commonly known as the Banjul Charter. And it stresses that every citizen has a right to participate freely in the government of his country, either directly or through freely chosen representatives in accordance with the provisions of the law. Now, in Uganda, where I sit at the moment, we have tried to domesticate this. We haven't traveled much, but we have tried. In Article 8A, it is stated that Uganda shall be governed based on principles of national interest and common good, enshrined in the national objectives and directive principles of state policy. I emphasize national interest and the common good. In that regard, Objective 2 of the national objectives is clear that the state shall be based on democratic principles, which empower and encourage active participation of all citizens at all levels in their own governance. Principle 10, it encourages government to involve people in the formulation and implementation of development plans and programs. In the main body of the Constitution, Article 38 is a replica of Article 13 of the African Charter on Human and People's Rights. But why do I point out this? It puts people at the center of decision-making. In Uganda, the most important article that I've always considered has been Article 1, which says that all power belongs to the people who shall exercise their sovereignty in accordance with the Constitution. It also says that all authority of the state, including the legislature or any other decision maker, emanates from the people, and that these people shall be governed through their will and consent. It requires that all authority of government and its organs derive from the Constitution, which in turn derives its authority from the people who consent to be governed in accordance with that Constitution. In Uganda, the people should be at the center of decision-making, legislative or otherwise. That is the legal framework that surrounds public participation in Uganda. But what stands at the moment? We have been moving, and as a legislature, we've had the tendency of the representatives thinking they can do as they please. After all, they were voted into authority. And that has been, until recently, has been challenged. And what have we come to learn? Our courts, where we go as the neutral arbiter, have been inconsistent in the application of this duty to consult or to allow the citizens to participate. While some judgments have upheld the fundamental duty to consult the public and involves them in decision-making in administrative or legislative matters, other decisions undermine this very important obligation. The duty, in my view, should not be perceived to impede decision-making, but as a constitutional matter of good governance. We've had some jurisprudence around the area, and in a few decisions that I will share in my presentation, there's the CFAO decision, where the first to be challenged was the Public Procurement and Disposal of Assets Authority, when it issued a circular amending the standard bidding document to include manufacturers, suppliers, distributors, and all that. 7 of the motor vehicle providers challenged this and contended that it lacked, it undermined the principle of fairness, transparency, and consultation in the public procurement process. Hence, compromising the quality of supplies and negating the value for money. On the other hand, the authority argued that it had no legal obligation to consult. And what did our court say? They said that the authority acted within its legal mandate and that the law does not impose a duty on the authority to consult every potential service provider or stakeholders. It also said that it would be impractical to consult everybody. And lastly, that the actions were aimed at promoting competition and ensuring value for money. Now, while this is the position that was adopted by the High Court, it disregarded an earlier position in Sepil versus the Attorney General, where it was ruled that an instrument, the instrument for the Rural Electrification Fund management, was invalid due to the minister's failure to involve the public, due to the minister's failure to consult. It was ruled that effective consultation is a mandatory procedural requirement for the validity of any legislation. The judgment underscored that consultation ensures that all legislation is made with comprehensive input and knowledge of the effective parties, safeguarding against improper use of power, and in particular, it highlighted 5 principles. And while I appreciate Mr. Ndakana, he went and touched these, and they came out when he was talking about the code of ethics. Unfortunately, where we come from, we do not have this code of ethics. It's a body we are yet to build, and it's a work in progress. However, the courts have laid down the fundamental principle that is a modern and effective technique of controlling exercise of power. Consultation of interests affected by the proposed regulations is important. Public participation is what is known as democratizing administration and the rulemaking process.
2 minutes, sir.
Oh, that is very fast. Secondly, the legislation passed with adequate knowledge of the problems involved, as highlighted by Mr. Ndakana, requires that the rulemaking agency has before it all relevant information. And so it should make the legislation with sufficient information. Where no formal consultative procedure is prescribed, the administration can still resort to formal consultation. I want to go to the Supreme Court. I will skip the others because I will share the presentation. Our Supreme Court has consciously said that unlike other jurisdictions, Uganda does not have laws or guidelines on how the public is to be engaged during the legislative process. And based on this legal fact, the court could not be in a position to question the modes of consultation adopted by Parliament. And as such, the body to determine the standard of public participation should be Parliament. And I stress it has not, because the only attempt has been in the objectives, national objectives and principles of state policy, which do not provide for something meaningful, but are couched in general terms bordering on abstract. It cannot guide anyone with any specificity on the mode of consultation and public participation. It is only the public hearings conducted by committees and people's involvement in decision-making through referendum that are properly structured so as to bring out the will and desire. I am concluding, Japheth. As I conclude, while our courts have tried and have been inconsistent, I think it is time for Uganda as a country and other countries to copy what has happened in England, where courts have upheld the duty of public bodies to involve the citizens in decision-making in what has been termed as the gunning principles. And what do they require? For you to satisfy that that you have involved the public, you should have shared the proposals at a formative stage. You should have provided sufficient information to give intelligent consideration. You should have given time, adequate time for consideration and response, and given consensus consideration to the consultation process before a decision is made. At our Parliament, we have not yet reached this level, but we'll do well picking a leaf. The courts have asserted within their limits the positive duty to consult and involve the public, and we should follow suit, since it is a constitutional requirement and a matter of accountability and good governance. I thank you, Japheth, and I will welcome the questions.
Thank you so much, Solomon. Thank you. We request the participants to hold on to the questions or put them on the chat. We'll answer them at the plenary. And somebody requested Solomon to share his screen. I think now that his time is over, he'll be sharing his presentation later. That was a very good presentation, Solomon. I know you for excellence. I'm surprised the team you support cannot follow your example, going even by yesterday's results. Now that we have moved from South Africa, East Africa, now we want to go to West Africa. And I want to invite the second discussant of the day, Benjamin Tachi Antiedu. Benjamin Tachi Antiedu. Mr. Antiedu is a senior public servant. He joined the Parliamentary Service of Ghana in June 2006 as a clerk grade 3, and has since risen through the ranks to the position of Principal Clerk Assistant, Legislation Office. He previously served as the Secretariat of the Committee of Parliament, including the Committee on Energy, Committee on Communications, Committee on Lands and Natural Resources, and the Committee on Subsidiary Legislation. He's a professional legal practitioner, having obtained his LLB from Ghana Institute of Management and Public Administration in 2014, and proceeded to obtain his qualifying certificate in Law QC from the Ghana School in 2016 and got called to the bar the same year. He also possesses a number of academic degrees, including bachelor's degree in land economy, master's degree in business administration, and master of laws in oil and gas law. Mr. Antiedu practices law on part-time basis at Gartney & Gartney, a firm of baristas, solicitors, and notaries public. His professional practice focuses on public law and legislative drafting. Mr. Antiedu is also an author and a publisher. He is the author of the book, Reading the Law, which offers a complete guide to the study of law in Ghana and other Commonwealth jurisdictions. Mr. Antiedu has participated in numerous local and international conferences in both his official and professional capacities. He's also participated in a number of public education programs in contemporary legal matters. He publishes articles and other papers on constitutional matters, especially those related to governance. It's now my opportunity to invite Mr. Benjamin Tachi Antiedu as our second discussant. Welcome.
Thank you very much, Mr. Moderator, for that lofty background of my humble self. Greetings to Solomon and earlier the presenter. I want to also thank very much our president, the president of the Colloquium, for leading this charge. Privileged to have joined this program, very, very insightful. And as head of legislation in Parliament of Ghana, I deem this as an eye-opener and quite timely at the beginning of my work in that office. So for want of time, I will want to beg that I take advantage of the background, the theories and the principles for public participation as succinctly outlined by the previous speakers. I want to emphasize one point, that the people are the center of democracy and governance. And for actors, we only act for and on their behalf. The Constitution of the Republic of Ghana vests the power in the people, as Solomon has indicated the case of Uganda, the same in Ghana. Article 1.1 of the Constitution of Ghana states, and I quote, that the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in the Constitution. So clearly, this emphasizes the pivotal role of the people in all aspects of governance, all aspects of our legislative work, particularly lawmaking. And when it comes to law, we all know that laws shape the social, economic, and political fabric of our societies. But the legitimacy and effectiveness of law hinge on the voice that we give to the people. Thank you very much. So I want to share the Ghana's, example in highlighting this very important pillar of our democracy. And I want to take you through briefly the lawmaking process and where, particularly, the people are engaged. The first point, methodology or approach that Ghana, adopts in ensuring that the people are heard. The first is that before even an ordinary bill is introduced in Parliament, it has to go through prior Gazette notification. I'm sure this applies to the situation in other countries, but the Gazette notification is a key element. 14 days, the people must know that Parliament intends to pass a particular bill, and that lays the foundation for them to prepare and make their inputs. And I must say and commend the Parliament of Ghana that in a new standing orders that has been passed, that standing orders ensures that every bill that is laid in Parliament, within 7 days, it has to be published on Parliament website. This is to ensure that after the people have been informed, Parliament will also make the text of the bill accessible to the people, based on which they can read and prepare their inputs. And when it goes to the committee stage, that is where the central processes allow the people to be fully engaged. So if I want to take you back a little, Parliament, we have a unicameral Parliament, and the process is quite simple. When a bill is introduced in Parliament, it's read the first time, what we call the first reading, and referred to the appropriate committee for consideration and report. And so when this happens at the committee stage, you have a key practice of the committees to publish, to invite memoranda from the public. And then where—
Just a moment, Benjamin. Just a moment, please. Sorry for interrupting you. I can notice, Ans Molomi, your hand is up. Is it a procedural matter you want to intervene, or else you may please put down your hand and put your question on the chat. Proceed.
Thank you very much, Mr. Moderator. So recounting the process of lawmaking in Parliament, a bill laid and referred to the appropriate committee for consideration and report. We all know that our parliaments are quite close. The public don't have access to the plenary. But when it comes to committee, the door is quite wide. So this is where the committees will even publish in the newspapers and also in the TV and even social media platforms to invite the public to submit memoranda, their comments, their concerns on bills to Parliament. Okay, so at this point, the committees will also write specifically to identifiable groups so that their input can also be taken on board. In federal state, the committees will hold stakeholders or public consultation forum. This is where those who have submitted memoranda and those who have not even submitted memoranda, but they want to make inputs, in a physical forum, they appear before the committees, make their concerns known, and then the committee will ask questions for them to explain further, to elicit more information, and also see what can be taken on board. This is not the end of the process. Parliament continues. Committee sittings are public now. So on TV, Parliament has a broadcasting station now, Parliament TV, where committee sittings are held in public and also shared on social media platforms live. So this is where the public will hear what every member is saying, and then the key concerns that are raised. And then they can also send messages, communicate with their members, and then get their inputs across. Further on, we have right to petition. In Ghana, any citizen can write to a member of Parliament, a committee, or the Speaker of Parliament concerning a bill. We've had several instances where citizens will write that we are objecting to the passage of a bill or a subsidiary legislation, and these matters are taken more seriously. So these are some of the basic mechanisms that the Parliament of Ghana use to ensure that the public is given due attention in terms of receiving their inputs, taking care of their concerns, and also making sure that their needs are reflected in law. Okay, so having gotten to this point, I want to raise some matters that are ongoing and that have raised some issues. We have not had the advantage of having specific judicial authorities, as I've mentioned in South Africa and Uganda, where the Supreme Court or your highest court has pronounced or have pronounced that public engagement should be the basic principle, and where there's a default, then that will even be a basis to annul legislation. But I must say that the closest we come to is the case of Justice Abdullahi, where Parliament made an amendment to a bill which was challenged, and that provision which allowed the Minister for Interior to grant licenses for cultivation of cannabis was annulled, and annulled on the basis that it was not contained on in the explanatory memorandum which should have accompanied the bill. And that throws more light on this principle that the public must be engaged right from the beginning so that they can be informed. They will also assess how the law will affect them and make the necessary input, if any. We still have some basic concerns which I will share so that colleagues may help or maybe share practices in their countries. We have this lingering issue of lapsing of bills when parliaments are dissolved and bills are unable to be passed. The status of those bills, per the practices in the Commonwealth, these bills lapse and have to be reintroduced before the new parliament. But you have cases where the bills have been passed in Ghana. Laws are made by way of bills which are passed by parliament and assented to by the president before they become law. We've had cases where a bill has been passed by parliament, dusted, everything done, and then the president is unable to assent to it before his term comes to an end. So the issue about what happens, this is a very important piece of a legal matter which must find expression in the law and should not be left to be determined on practice. Okay, and then yes, you have lovely situations of the role of the judiciary in the process, in the lawmaking process, ensuring that the citizen input is taken. But that process can also hamper the making of laws and all that. So we have to find a way that the laws can be made, without unnecessary interference from the court, but on the basis of public engagement and some substantive matters that must be allowed. But the case I cited, Justice Abdullahi, where the court is saying that even a bill before parliament, when parliament is more or less restricted as to the kind of amendment to be made. If the amendment will go to the core of it, then the court is saying go back to the people before you proceed. We think that may obstruct the lawmaking process. And then when it comes to subsidiary legislation, these are called delegated legislation in some jurisdictions. And for these laws, the process is a bit closed. Once they are laid before parliament, 21 sitting days, they become law. And that does not ensure full public participation. And so we want to listen to colleagues as to how delegated legislation or subsidiary legislations are managed in their countries. Thank you very much.
Thank you so much, Benjamin. Actually, you have kept your time without being prompted. And thank you for that. And we really appreciate the rich contribution from the Ghana jurisdiction in West Africa. At this point, allow me to acknowledge the presence of Dr. Gloria Kenyatta. Dr. Gloria Kenyatta, she's the Deputy Clerk, Bomet County Assembly. We'll be revisiting our presence and our contribution later in the Q&A session. At this point, we want to invite a very special discussant from the Northern African region of the Colloquium, and that is Mohammed Rafi Said Al-Subaihi, our third discussant. I want to confirm, Mohammed, because I know we are utilizing interpretation services, kindly confirm that you can hear us before I introduce you. Is that a confirmation?
مش عارف رديت يا ريت تعاود السؤال على الترجمة بس.
Thank you so much. Now, allow me to introduce our discussant, Mohammed Rafi Said, who is of Libyan nationality, and his position is the Secretary of the Legislative and Constitutional Committee, House of Representatives. Secretary of the Legislative and Constitutional Committee, House of Representatives. Previously, he held the position of the legal member, Legal Affairs Department, House of Representatives, and position of legal advisor, Committee on Public Freedoms and Human Rights, House of Representatives. In his education qualifications, Mr. Mohammed has a bachelor's degree in law from Faculty of Law, University of Benghazi, a very beautiful city where he hosted as not long ago. Higher diploma in diplomacy, protocol, and etiquette, British University Institute of Diplomatic Studies. He also has an international computer driving license, ICDL, training course from Al Burak Institute for Information Technology Solutions, accredited by the Libya Quality Assurance Systems. He has done a number of training courses from labor and public service, legislation, international law and international treaties, and even training of trainers, both from local and international organizations, and even on combating trafficking and smuggling in persons. I now pleasure to invite Mr. Mohammed Rafi Said to give his presentation as our discussant. Thank you. Welcome.
بسم الله. السيدات والسادة الحضور، السلام عليكم ورحمة الله وبركاته. صوت واضح. في هذه الندوة الإلكترونية لمستشاري البرلمانات الأفريقية، هل الصوت واضح أو لا؟ لا أعرف.
Yeah, Mr. Mohammed, is the translation working? Because we should be receiving it in English.
Yes, the interpretation is on. Technical team, please confirm that we are able to get the correct field of the translation, because I think we are getting the first input, that is the Arabic language. We should be getting maybe English or French. Hello, Mr. Moderator, can you hear the interpreter? Can you hear the interpreter? The interpretation is on. Can you hear the interpreter?
Yes, we can hear the interpreter.
Okay, proceed.
السيدات والسادة السلام عليكم ورحمة الله وبركاته.
Ladies and gentlemen, may the peace and blessings of Allah be upon you all.
هل الصوت واضح؟ شرفني أن أخاطبكم اليوم بصفتي أمين سر اللجنة التشريعية والدستورية بمجلس النواب.
I join you today in my capacity as the Secretary of the Legislative and Constitutional Committee, House of Representatives, and I'm glad to participate in this webinar that discusses the public participation. This webinar will hopefully open new horizons for us to understand the importance of public participation. Ladies and gentlemen,
لا يقتصر فقط على دراسة مشاريع القوانين وصياغتها، بل يتعدى يشمل حماية الدستور لا يخفى أن دور اللجان التشريعية.
All of us know that the legislative committees in Parliament do not just work on preparing bills, but also ensure that the public participates in the process of preparing the bills. Therefore, the Parliament should take into consideration the role of the public. It is important for us to engage the citizens. This is not an option, but it is a democratic imperative. The Legislative and Constitutional Committee in the House of Representatives in Libya has worked through very difficult circumstances, given what Libya has gone through, but it has worked hard to ensure that public participation is conducted. It has consulted a number of entities, and particularly civil society, before drafting any bills. We have in Libya Act number 4 on public participation, and which requires that bills should be passed through the executive authority as well as the House of Representatives. Again, public participation ensures that the legal frameworks and the bills that are prepared are in consonant with what the people want. And that also happens whenever there is need to amend any of the laws. Therefore, the law must take care of the environment in which it operates. Again, we in Libya, we face a number of challenges. Among them, the need to digitize the process of preparing or drafting bills so that the bills can come out in an appropriate manner. And we also need to ensure that we involve the public opinion in drafting our laws. We also have a challenge that is seen in our inability to align our laws with the international conventions and laws. But Libya has worked tirelessly to set up democratic institutions as well as ensure the development of the community. Therefore, we would like to say that this webinar is an important platform which will reflect the view of the African continent in the legislative process. Therefore, it is important for us to cooperate in order to deal with challenges such as crime and cyber crime and human trafficking, as well as human smuggling.
المشاركة المجتمعية
Therefore, public participation in drafting laws has a number of positive aspects. Just like.
Can we take a short break, please? I know you are 5 minutes into your presentation. Just 1 moment break. I've seen a number of participants saying that they are not able to enable the translation. Is any member of the technical team able to step in and give a quick advice? Or no members need to enable? A number of people are put on chat that they can't follow the English translation.
Good afternoon. Kindly go press the 3 buttons on more. Then once you press that, you can see interpretation. Then you choose English.
Thank you so much. You have hand. Go to the 3 dots below your keybar. Press there and go to interpretation and select English. Thank you so much. Proceed with the presentation, please.
واصل معي من الأول. مسألة الصياغة التشريعية وهو ما نسميها الآن المساهمة في صناعة التشريع.
Public participation in the preparing bills as well as legislation has a positive aspect because this process ensures that the bills and the legislations that are enacted take into consideration the needs of the environment. Therefore, we see that it is extremely important to involve the public because this makes the public part and parcel of the law, and the public understand why the law was enacted. Therefore, the House of Representatives in Libya has worked to ensure that it is part and parcel of this process. It has come up with mechanisms to ensure public participation because the House of Representatives in Libya understands that this is one of the mechanisms that will ensure that the country enjoys stability. I thank you very much for your kind attention.
Thank you so much for that presentation. And apologies for those who under the challenge of translation. I needed technical team. We needed to communicate that at the beginning, but I think we'll get both versions of the presentation. We have now our then discussant. I want at this moment, we have overshot our time a little bit, but I want at this moment to invite for the discussant to also welcome us. Professor Nyokabi, you have heard from the practitioners in all regions of Africa on the period of public participation. And now we want to invite you, the Executive Director of our Center for Parliamentary Studies and Training, to give your thoughts on this process. I know you are a scholar and an academician, and most of those people who have been presenting are advocates, lawyers. But from you as a trainer, you train us, you train our honorable members, you train our technical staff, including us lawyers. You can quickly share your points in 2-3 minutes on your experiences and what you are doing about public participation. Welcome, Professor Nyokabi.
Thank you, Mr. Modomi. And I think we could mute, the host can mute the team from North Africa. Okay, now they're muted. Thank you. Thank you, Modomi. I'll take maybe less, but if 3 minutes are done, that's also well. I've really enjoyed listening to the perspectives of the South, the East, the West, and the North. And although the North, I got it more at the tail end when he was actually finishing. But for me, what stood out is we seem to have very similar provisions, particularly the South and the East, if I was to include Kenya in the Uganda although Ghana seemed a little bit different. I don't know whether for theirs is in the constitution or not. But the standing out of the sovereignty belongs to the people. The sovereignty is with the people. But then I'm always confused by that, and the lawyers can unpack that, you presenters can. We have done these public participation discussions quite a bit. And in Kenya, what seems to be coming out is that even though the sovereignty is the people, they have delegated it to their elected representatives. They have also delegated it to the executive and indeed also to the judiciary. So for us, the big issue that seems to come out
للسلطات المختلفة بما في ذلك السلطة التشريعية والتنفيذية والقضائية. ولكن السؤال الذي يطرح نفسه هو
I'm asking. South Africa, you said you're a country of diversity. No wonder you're called the Rainbow Nation. And every country is diverse. Kenya is extremely diverse. Uganda is very diverse. Everybody these days has an opinion on everything. So what is the best way to make the country even move? And how much is enough consultation? In our country, we are having consultations at the National Assembly. The matter goes to the Senate, there's consultation. The matter, if it's, say, the finance bill at the county level, you know, all these matters are discussed at the national level, then they go to make the finance bill at county level. There's further consultation there, and those people of the counties were the ones being consulted by national government. So it also becomes a point where we have also overwhelming our people. What is a good balance? And you all quoted the issue of sovereignty of the people. But at what point does it get delegated to a point where you can trust those you have elected to do the job? And to what extent then must you keep consulting? How much consultation can you do? I would also have liked to hear from yourselves, the legal team, what the rest of the world is doing. Because Africa has moved very ahead in laws. But then when you look at what is on the ground, and all these countries, apart from Algeria, I haven't been. I go to South Africa, I come to Uganda, I come to Kenya, I come to Tanzania, I go to Ghana. We are just having a lot of problems. I mean, there are just so many problems on the ground. People are just, really, there's a lot going on. And yet we have these beautiful laws. When you go to other countries, maybe the laws are not that much. It's even more organized. So for me, it's, what do we
إذا بالنسبة لي ما الذي نريد أن نعمله لأن نضمن مجريات الأمور بصورة جيدة.
Speaking as a sociologist, as a social worker, do people want services, or do people want you coming to consult them every single day and it never translates into law? What do people really want? And it's just a question of asking, how do we make ourselves more efficient as governments, so that our people can feel that sovereignty really matters. I want to end it there. I hope the lawyers are in the room, particularly the keynote speaker, and even the discussant could come into that. But I really appreciate hearing all the perspectives from the different parts of the continent. Thank you.
Thank you so much, Prof. We do appreciate your summary and also the queries you have put. You have asked a technical, both a technical and a political question. Trust a professor to go political. On wondering how come we have the good laws and yet the outcomes or the impact of these laws, wondering whether it's working. We appreciate the presenters so far, both the main presentations and the discussants. We have heard from the South, who is really like our parents of public participation. With all the cases, we have Anne Mogale and others versus Speaker of the National Assembly, Doctors for Life International versus Speaker of the National Assembly, as we appreciate that almost all these cases are against Parliament. But I'm glad we have plenty of questions coming up, and the plenary session, the Q&A we are going to now, we'll have an opportunity for the presenters and discussants to interact with you. I'll start with the ones that are on the chat, and we'll take 15 minutes because we have taken a little bit more time than expected. I'll pick the question up, and I'll give the main presenter the first go, and the discussants will give their bite as they followed each other. The main presenter may take 5 minutes, then the discussants can take 1 to 2 minutes. And the first question came from Gloria Kenyatta, who says us that the Constitution envisioned, how do we streamline and enforce Now, I think, yes, I think gotten the right question. She understood that an expert in public in participatory democracy and where she works, and her question was, how do we deal with the public apathy in public participation, especially in Kenya? The High Court having given directions on the quality and the quantity of public participation. So public apathy, how do we deal with it? Then the second question was from Deborah Mupusi, drawing from the experience of the presenters. What are some of the most effective communication strategies that have been successful for public engagement and transparency? And then there are several other questions. Thanks, Solomon, for trying to answer those two questions. Then there's an anonymous attendee who asked, how can legislature build internal capacity, staff, resources, and training to manage participatory processes effectively? I take note that our main presenter is actually a director in public participation. You can advise us on that. What strategies help institutionalize participatory practices so they are not dependent on the political will of the individual leaders? What strategies help institutionalize participatory practices so that they are not dependent on the political will of individual leaders? I would particularly be interested to hear from the Ugandan jurisdiction on this. Then there's another question from Gloria. One of the major weaknesses we have is lack of feedback to the citizens. All public views should be accounted for. It is disappointing when the public give their views and no feedback is given, or when given, it is inaccessible to many due to channels used, e.g. websites and all that. So could diversification of communication channels work? We'll hear about this. Anonymous participant asked, how can citizens and civil society organizations track whether their input has been taken into account in the final legislation? Very important question. Are there other jurisdictions with overreaching laws on public participation, and has that led to improvement of quality of the public participation processes in the legislature? Another attendee asked, how do we ensure diverse and marginalized groups can effectively participate in the legislative process? People who are marginalized and in the far-flung areas, how can we ensure that they effectively participate? Another question is, it is not possible, oh sorry, that was a comment. Then another question, how can legislatures ensure that information and decision-making processes are transparent and accessible? Are there mechanisms for holding decision makers accountable to public input? Then the final question on chat. I'd be interested to hear from the speakers how their stakeholder mapping is done. Simply give insights into this, because in public participation, everyone should participate, and this mapping should be done from the lenses that are free from power matrix. That is in brackets, power, influence, or interest, or importance, to facilitate inclusivity and equality in participation. Those are the questions in chat. I will invite the presenter and the discussants to give a go. Don't spend too much time on answering. If a question has been answered earlier, you can pick up what has not. Starting with our main presenter, kindly, the floor is yours.
Thank you for the insightful contributions by fellow participants and all the questions that have been raised. I think one of the things that the Prof mentioned was the question of the diverse community that we have in am I audible?
Yes, I can hear you from my side, Mr. Jongi. I can hear you.
Oh, okay, thank you so much. One of the things that we are trying to do is that following some of the interventions made by the Constitutional Court of the Republic, in us not providing or creating enough time, one, but two, appropriate audience that is affected by the legislation under review. Is that what we did is that the legislative sector is looking at the turnaround time that we are provided. One, for legislation that affects the province that needs to be decided upon at national. Because remember, we've got National Council of Provinces, which caters for the provincial interest at national parliament. So we ensure some of the legislations that are going to be considered and voting mandate sought for our permanent delegates. All these public hearings are conducted in time. And as one of the things that arrest the problem of sufficient and adequate public input in our processes, one, we ensure that before the actual public hearing, all the interest groups, the advocacy groups, the stakeholders within the environment where the piece of legislation is going to be considered, we conduct what we call pre-hearings, where we go through each and every issue that is highlighted by the intended policy development. Number two, one of the areas that I think that was raised was the question of the relationship of practitioners and public representatives. Remember, we as practitioners provide support to public representatives to conduct their work. One thing that we have also done is that their constituency offices are often used as the site of extension of legislatures, because some of the communities may be difficult for them to reach the legislative seat. So each and every time, or once in a while, when the member is doing constituency work, we will accompany them so that the constituency where the member is residing, we will be able to explain some of the policy developments that we want to achieve. But one other thing that we are doing, we are also using the regional media, especially with respect to the language that are used. We would target a regional media station or TV that is operating in the area, and we will use the phone-in sessions with the chairperson of a portfolio committee so that we explain some of the issues that will be under discussion. I think the other thing that is important, it's what the legislative sector of South Africa is doing now is to develop a stakeholder strategy framework, which is going to zoom in specifically to the type of stakeholders that the legislatures and parliament have been missing all the time because of the constitutional court judgments against us, because of the issues of one that has been raised by some of the discussants, lack of feedback and apathy as a result of people seeing that these platforms are often used as talk shops. There is nobody that is coming and tell them that their input has been embraced and so on. So we are trying to change that perception amongst our people and ensure that this is reflective of the input that they made. But the last point that I want to make is that we have also developed a petition system where communities, interest groups, individual members of society can petition the legislature should they feel aggrieved on the lack of service delivery by a local government. Those are some of the things that portfolio committees of the legislature sometimes seek to make interventions either by meeting the local authorities, the mayors, executive mayors, and speakers, to try to deal with issues before, for an example, people start picketing and protesting and so on and so forth. It has been difficult, of course, because the communities at times don't make a distinction between a councillor, a member of the legislature, and the member of the national parliament. They always see them as one thing, government. So if they don't get services, their anger is targeted towards government. Thank you very much. I hope I'm trying to move with speed so that I address some of the things.
Thank you, Jongi.
Thank you for the opportunity.
Thank you even for the answering the queries, and especially the general one raised by Professor. I want to invite discussants, starting with Solomon. Give it at least 1-2 minutes take on the questions asked.
Thank you, Japheth, and I just want to say one thing. It all goes down to public trust. In terms of answering the apathy question, if the public does not trust that their input is going to be considered in decision making, then we shall have no way of fighting apathy. But if they know that, 1, enough information will be given, 2, it will be given early, 3, consideration will be given to their ideas, then they will turn up and they will stand up to be counted. The other is, do we give them sufficient time to do this? Once that is available, then we think it will take us a step forward. 2, the administrators or decision makers or legislators should appreciate the fact that the positions they hold are held in trust for the people, and therefore the element of accountability. Do we as an electorate hold these legislators accountable? Do they feel accountable that whatever they will do, whatever decision they take, legislative or otherwise, they will be held accountable? Once they do that, then they know that the standard is high and that the real master is the people. The courts, the public, and everybody has a role to play here. When it comes to stakeholder mapping, I just want to say that is determined, for example, in Uganda by the subject of the decision. If, for example, it is a law relating to lawyers, I will need to say, I will need the law society, I will need the judges, I will need the judiciary, I will need whoever. If it's a law or a decision affecting vendors, I shouldn't go and consult statisticians. I have to go to the vendors. So the subject of the decision and then the affected persons in this decision. If it is a project, who are the project affected persons? And what language will I use, or what language is required for this message to be delivered? Lastly, Japheth, on capacity, I think CPST is doing a great job. This is part of building capacity for the staff and all the others. Then we setting benchmarks. If as institutions and as governments, we could set benchmarks, that this is the basic standard for examining a piece of legislation or a decision before it is brought onto the public. In some areas, you must have put out a white paper or a green paper. You must have done A, B, C, D. Then, if that standard is not met, the decision shouldn't be implemented, should be held. The other things, Mr. Ndakana really spoke about them, and I don't think I should belabor those points. Thank you.
Thank you so much, Solomon. 1 minute for Benjamin. 1 minute for Benjamin.
Yes, thank you very much. I must say I've learned a lot from this platform. Yes, on the question of the power belongs to the people, and then they delegate it to elected officials. So why the need to further engage them? As has been said by Solomon, there's a trusteeship position, and that the principals remain the people, who are encouraged to be active citizens and not spectators watching what their elected representatives will do, because we have found that you don't have to wait for 4 years, for 3 years, for 5 years before you hold them accountable. Accountability and ensuring that the needs of the people are taken care of must happen day to day. And the question also about how much consultation to be given in terms of the quantity and quality of consultation. As has been said, it all depends on the bill or the measure in question. If the measure is so wide and has a broader coverage, then you must involve as much people as possible. In Ghana, where we have a more cross-cutting legislation, regional fora, Ghana has 16 regions. The portfolio committee will hold regional settings, public hearings where people walk in, speak any language that they want, express their views about the law or the measure, and then they are taken care of. The difficulty has been, how do you track civic input? I think that is a matter that we have to take care of, because most of the time, what the people want may not be expressed directly. It might have been taken care of in one way or the other, and it might not be so expressive on the face of the measure. And that, I think, we need to look closely before we do that. Yes, we have people who we have entrusted our power to make the laws, adopt measures on our behalf. So they may not act ditto what we want. But the fact that you are ahead, the fact that they have taken it into consideration in their consideration
في الاعتبار، فلا بد أن نحاسبهم. وشكرا جزيلا.
Mudomi, you're mute.
Yes, thank you so much, the West African, Mr. Benjamin. North Africa, Mr. Mohammed, any comment on the questions raised and maybe as your last point? Mohammed Rafi? You're on mute, sir. I think it's only fair that we also hear from them.
سيد محمد الآن في اجتماع مغلق.
Mr. Mohammed is at a meeting now. He will come back. He's currently in a meeting.
Thank you. That is noticed. Yes. Okay. Now, at this point, I want to appreciate everybody who has contributed, who has asked questions, who has participated. There are still more questions on the chat, which I think I've seen some presenters are actually answering them on the chat, and I appreciate that, because we have exceeded our time, and it's only good that we keep our discipline in timekeeping. I just want to take this opportunity to thank you and tell you that the fact that we cannot even exhaust the questions and the content we have within the time we have tells you that this topic is ripe and rich for our democracy and our lawmaking processes. Particularly in Kenya, I've had the benefit of being both in communication and information sharing and the legal side. And there was an interesting question, particularly on mapping. I've noted in Kenya the way we structure our public participation process. There is what we call the public hearing. The public hearing, and we generally open up to the members of the public in public forums, just to anybody. Then there is a stakeholder engagement, which also is a critical stage. We invite the people who are directly affected by that legislative proposal, the law that is being considered, the bill that is being considered. If it's a professional body that would be affected by its implementation, if it's a certain group of farmers, they're invited as groups to give their views. And then there's the third stage of expert views. They are experts in any particular area. and they are known, they are possibly even in the hands of their professional bodies, professors at the universities on that area. They are also invited to give their views such that the views are encompassed. And finally, the other thing I've noted is that when the oversight bodies, the checks and balances bodies, the accountability bodies are working, there's no choice but to do it right. I saw a question whether we just do it to tick boxes and comply with the law. When courts do not hesitate to declare acts of parliament unconstitutional, like you find in South Africa and Kenya, and I'm sure in other jurisdictions, parliaments will go out of their way to ensure that they do the right way, the correct process. I've seen in Kenya, us go out of our way, even record video and photo evidence of this public participation to even show the crowd that attended. And when people give their views, they also fill the forms. We interpret the bill into decisions. Do you agree with the clause A, clause B, clause C, and all that? And people sign up and give their views, and we keep that record, and we file it in a very meticulous way, expecting some legal contest in court, and we'll have our evidence in place. So again, when we have other bodies like the courts and possibly the people giving assent, working and effectively working, parliaments have no choice but to embrace the correct public participation. As I said, that's what I'll say last as a moderator, but I also want to appreciate the Colloquium for Legal Counsel for Parliament in Africa, even for organizing this event, and particularly this capacity building for legal counsel. And I want to acknowledge the presence of council members who are in the House, who lead us in these activities. And I want to start with Asaf Ntanda. If you are in, you may just lift your hand on the chat. Then Fares Hamand from Libya and Doko Ngumenze. Those three sit in the training committee of the Colloquium. Colloquium is made of the legal counsel who work for parliaments in Africa. And then we also have Tangela Sam, who is also present with us. Thank you so much, council members. Otherwise, it has been a pleasure to moderate this session. Professor Nyokavi, if you are in, I'll give you the last chance to thank everybody and close for us. Thank you.
Thank you. I see Mohammed is back. Don't know that he might want to say something before we close him out. What do you think?
Yes, Mohammed, if you are back, you may give a quick feedback concerning the questions that were raised before we close.
Maybe it's not him on the table. Let me just go ahead to close this session by thanking each one of you. And I think the issues that we have raised is to really think through as Africans how to make this public participation not an end in itself, but a process that now makes the services given to our people better, so that the lives of our people can improve and people can feel that government serves them. I think that's the outcome. The real outcome is that our people feel happy with government, and that their involvement is not just for the sake of it, but it is for an outcome that is desirable. With that, I want to really thank the keynote speaker joining us all the way from South Africa. Thank you very much. That is Mr. Jongi, is it Jongi or John Dakana? Jongi or Jongi Dakana, we thank you very much.
It's Jongi, Prof.
Jongi.
Yes, Prof, thanks.
Because I thought there was an apostrophe, which would make it Jongi in my language, which is not a good word to call someone, but Jongi. Yes, indeed, Jongi. We appreciate you very much for your time, for your presentation. We appreciate the discussion from our neighboring country here, Uganda. I love your ending point at the end, that finally what we need is a clear benchmark. And the legal colloquium can actually come with that of saying 1, 2, 3, 4. Once you've achieved all that, and then it's acceptable, then that is enough public participation. And that should be something that you can contribute to our parliaments. I want to thank Benjamin from Ghana. Thank you for your ideas and what you're doing in Ghana. We appreciate. And finally, Mr. Mohammed Rafi, I wish I had you more, but we'll get the presentation, and indeed we should be having more engagements with the colloquium. I want to thank my own people here. Jafed, you've done an excellent job. You've done really well. You've managed this team very well, and I'm glad to hear that you're in the first Colloquium. You served in the Secretariat of First Colloquium. It's no wonder then you studied law later on, because you must have seen and excited and admired what the lawyers were doing. So well done for actually now joining properly as a member. And Wayua Mutisia, our chair of the webinar committee, and the entire team that works with you, Wayua, we appreciate you, and we want to apologize for the hitch, especially on the translation when Mohammed was speaking, but otherwise this has gone really well. And I look forward, Mudomi, and your leadership of this colloquium that will organize others and with the objective of making Africa better, that parliaments serve the people and serve the people well, and people feel well, so that when we go around the countries in the continent, we are happy that indeed our people are well served. With those many remarks, allow us to stop this and end the webinar here, and all the best wherever you are, and God bless you. Asanteni sana. Kwaheri. And welcome to CPST. We have many courses. Check us on our website. Check us on our the calendar. I cannot forget to advertise. We have many programs running. They're on our website, social media pages. Please check us out and join other webinars that we run. Every month we do run a webinar. Asanteni sana. Good afternoon. And good morning.
Professor, you forgot that the Ghana, your main client.
Ghana, and they are competing with us big time. I was there recently, and they have a very good parliamentary training institute. I was very impressed by the facilities there. But you know, we are the big sister, so keep giving us business. Even South Africa, Uganda is a big partner of CPST. We are available to give you many both bespoke programs and those that we are on the calendar. We are always available. Call us, email us, we respond in real time. Asanteni sana. Good afternoon.
Good afternoon.